When you hire an attorney to evaluate your DUI charge, the attorney looks at the many different parts of a DUI, starting with the driving or the reason the officer came into contact with you. That initial contact has to be lawful. The officer has to either have observed some sort of violation of the law, whether it's a traffic violation such as not using your turn signal or coming to a complete stop or swerving outside of your lane, or the officer may approach your vehicle if you're in a parking lot for purposes of community safety. If you're sitting in your car in a parking lot, say in the middle of the evening. Also, citizens in the community are allowed to call in what are called ready reports, report every drunk driver immediately. And if a ready report is made and an officer is able to find the vehicle matching the description of the vehicle being described in the report, then the officer may come in contact with that driver. So that's the first part of the DUI that an attorney will review. The second part is, did the officer have reason to believe that the person was drinking and driving? That is, if they do stop you for a traffic violation, are they then able to tell the court why they turned that traffic stop into a DUI investigation? They must be able to show the reason that they then decided to investigate you. Once that step has been accomplished by the law enforcement officer, the officer then must have probable cause to believe that you're unable to safely drive or that you're over the legal limit. And again, after that phase of the DUI investigation is completed, the officer places the person under arrest. They must, in fact, place you under arrest, tell you why they're arresting you. And then once you're in the detention center, they will ask you to take a test of your blood, breath, or urine, and that test must be performed accurately and documented accurately. So our office checks to make sure that that phase of the DUI is also conducted correctly. And if at any of those different phases law enforcement has done anything incorrectly or violated your rights in any way, then we're allowed to file a motion before the judge and basically complain to the judge that the officer didn't perform the investigation properly, and ultimately ask that the evidence against you be suppressed. And without the evidence, the prosecutor will then be unable to prove its case beyond a reasonable doubt.